Institute for Reforming Government is well, I would say one of the premier organizations in Wisconsin that follows a lot of what's going on in our Wisconsin Supreme Court. And grateful, Jake. I know he's on one of these lines, so hang on a second. Good morning. Is this Jake?
This is Jake.
All right, good. All right, Jake, because another one of my lines is ringing oddly. But all right, Jake. So IRG Court Watch. Let's talk.
Yeah. So sorry about that.
Yeah, we got disconnected or something.
Yeah. So this week was a big week for IRG. We put out a kind of term in review that is a pretty comprehensive review of really all the major decisions issued by the Wisconsin Supreme Court. We spent a lot of time on this, and really was building on the work we've been doing since February. Right in February, we launched our Court Watch kind of project, and that's probably going to be an ongoing, permanent project at IRG because we think it's really important to focus on the Wisconsin Supreme Court. Lots of groups pay attention to the U.S. Supreme Court, and we're going to do some of that, particularly any decisions that are on appeal from the Wisconsin Supreme Court. At the U.S. Supreme Court, obviously, we'll pay close attention to those, and then any other decisions that will have a direct impact on, Wisconsin residents, businesses, state government. But what we really want to focus on is the Wisconsin Supreme Court and the Court of Appeals, as we'll get to here in a second. I think because of kind of how the Wisconsin Supreme Court and the current progressive majority is frankly running the court, I think courts of appeal, there are 4 district courts of appeal in Wisconsin, I think those are going to be critical. But so we put out this report yesterday. I think it has gotten we've received really good feedback. I think people appreciate a thorough review of the key decisions, but that's in an easy to read format, right? This is not a law review article. For those of you of your listeners that are familiar, a law review article usually, well, they're deep dives.
Right.
They're usually 50, 60, 70 pages, and they're important, right? They're scholarly work, but that's not what this is. What we wanted to do is put out a report that really anybody can pick up, attorney, non-attorney, and then we focused. We didn't review every single case, although we probably could have. I mean, one of the storylines here is that this court, this majority, continues to issue a low, historically low number of decisions. Last term, I think we've mentioned before on your show, Meg, that last term, or the term before the most recent term, it was 14 decisions. As best as we can tell, and there's a professor at Marquette that does a great job tracking the number of decisions issued. The best I think most of us can tell, that was historically the lowest number of decisions issued ever, at 14. This term, depending on how you count some of the orders, between 22 and 24, still historically extremely low. We actually have, we partnered up with the Marquette professor, and he was willing to let us cite to his work. We have his 2 charts in our report. I'm just looking at it right now. You can go back to 1922 to 1923, around 300 decisions in a 2-year term issued by the Supreme Court. You look at the early 30s, the number is approaching 400. Now, that was at a time when the court was looking at, even minor issues that might not have had, statewide impact. So certainly a different era. And so even if you grant that, though, if you look back to the mid-'80s, so, let's just say kind of modern political history in Wisconsin, or judicial history in Wisconsin, 1985 to 1986, around 70. Even as recent as 2005 to 2006, that number is around 95, right? And so 2023 to 24, you have 14 decisions issued by this court. And I think that's important for several reasons. One, it really emphasizes any decision that the court issues is likely going to be extremely important. So again, this term, despite only having around 24 decisions issued, we highlight 10 of them because we think they're extremely significant. and are going to impact state operations, religious liberty, abortion. Right, so the court is taking up big issues, and we can get to some of those big decisions here in a second. The second thing is, as I alluded to a moment ago, I think it makes the courts of appeal really important. Again, there are 4 districts. District 4 is based out of Madison. Look, the reality is it's going to be difficult for a conservative to ever be successful in a race there. Just like Supreme Court, they run every 6 years. So Supreme Court's 10 years, Court of Appeals are 6 years. It's going to be really tough for a conservative to ever win in that district. District 3, which is in your neck of the woods, Meg, there's at least one really good conservative judge, Judge Cruz. That should be conservative, and that's maybe some conservative court. That's something maybe conservatives need to look at in your neck of the woods. There's really not an excuse to not have a conservative court up there. There's only 3 judges that actually sit in that district because there's 5 that sit in District 4. And then you have the Fox Valley, the Milwaukee County, which is its own district. That's always going to be tough. And then you have District 2. And as conservatives, we need to be smart and focus on a district like District 2. That should be all conservative judges. And there's actually a pretty key election this spring. You don't often get a contested race for the Court of Appeals. I think the incumbent is going to run, Lisa Neubauer. Anthony Lococo, who used to be counsel at IRG and Will and Harvard Law grad.
I love Anthony.
He's amazing.
Mm-hmm.
He's running for that seat. I don't think Judge Neubauer has actually announced, but and if you look at her fundraising numbers, that's another one of those examples where she's not raising really anything. So one has to wonder if she's going to run again. So if she doesn't, that's a great pickup opportunity for Anthony. And if she does, I still think Anthony's going to have a great shot. And I'm thankful that the grassroots they identified that race. Anthony had the courage to step up, and we need more of that in Wisconsin. Because, again, going back to the report, because the Supreme Court is not taking up as many decisions, it makes the courts of appeal all the more important. Those are essentially in many cases, going to be the courts of last resort. In other words, that's kind of the end, right? If you have a legal dispute in Wisconsin under state law, there's a good chance that you're not going to get to the state Supreme Court. And so it's really critical that we start focusing on courts of appeal. At some point, we're going to be putting out a scorecard and hopefully looking at courts of appeal. And that's down the road for our Court Watch program or project. But that's something we want to do. But so for right now, we think this was a great start to look at the last term, to focus on the 10 key decisions that the court issued and to see if there were any sort of trends. And I'll stop there because I think there are some trends, and I think you kind of know where we're going with this.
Well, yeah, let's keep rolling with what you're seeing. I mean, I think what's frustrating is that we're not going to have a majority for at least 2020 until 2028.
Well, correct.
Ugh.
If you look at the current makeup of this court, it's obviously 4-3 progressive. There is, as I alluded to earlier, there is an election this spring, and unfortunately, we're playing defense. It's Justice Bradley's seat. She's announced, or she's made statements indicating she probably is going to run. I'm not so sure. If you look at her fundraising numbers, they're not great. I certainly hope she does run. She would be by far the strongest candidate. She has the advantage of incumbency. Anybody that has followed the courts know that she has issued some of the strongest dissents. And occasionally, when she's in the majority with the progressives, when they're willing to go along with her, she's issued some wonderful majority opinions as well. And certainly when we had the majority, she was a lead author on many critical decisions. So she's just, I say this trying to be as objective as possible, but she's rock solid. And again, when you're a judge or a justice, the proof's in the pudding, so to speak. We see all their work product. You can't hide behind a committee or anything like that. Not to say legislators ever do that, but you can't hide behind procedure. You're out there. You're exposed, and people can judge you based on your decisions. And she has just been a consistently outstanding justice. And it would definitely be a loss if she decides not to run again. And even if we have a conservative step up, if she decides not to run, that's going to be an uphill battle. And then even if they win the race, we're still just preserving the status quo, which is 4-3 progressive. I believe then at that point, the next opportunity, because I think the race after that is Justice Ziegler. I don't know if she's going to run, but if she does, we'd be in a similar situation where we're just preserving the status quo, which is 4-3 progressive majority. And then, yes, 2028, I believe, would be the next opportunity to actually flip the court. So these races, I hate to break it to your listeners, there's no let up here. If you care about the courts, you just need to continue to remain involved. But again, back to the report. There's a couple of interesting things, Meg. First, we try to be objective, and I think we were in this report. There were some decisions that this court got right, in our opinion, and we're willing to point that out. And so I guess this narrative that this court is just completely out of control is not necessarily correct. On the one hand, this was the most progressive court since 2008. I think that is a fair statement, right? If you look at 2004 to 2008, that was kind of the height of the Chief Justice Abramson era. You saw decisions like the risk contribution decision involving lead paint manufacturers, where basically, they didn't even require causation. Just look, if you were involved in that industry at a certain point in time, we'll assign some liability, which is just absurd if you think about that. But that was the type of decisions we were seeing out of the Abramson court. We were able to flip that, and we had a pretty good run, about 15 years of conservative courts issuing solid decisions based on an originalist and textualist view of statutory interpretation in the Constitution. That ended in 2021, and now we've had a run of progressive decisions. And so we thought it was important to kind of take a snapshot. What did the court do the last term? They showed some restraint. So, and again, we're not, hopefully people understand, we're not talking out of both sides of our mouth. On the one hand, this was the most progressive court since 2008. On the other hand, there are examples where the court showed some restraint. If you look at legislature versus DPI, this is the case involving the partial veto of the literacy bill that we certainly advocated for. The court held it was unconstitutional. That partial veto by the governor was unconstitutional because it was not an appropriation bill. In other words, you can only use a partial veto on an appropriation bill. This was not an appropriation bill, and therefore the partial veto was unconstitutional. That was a 9-0 decision. The progressives went along with Justice Bradley. It was a unanimous decision. She was the lead author. So that's an important decision that you have to point to that the court got correct. If you look at election administration, Weck versus LeMahieu, that's a tough one. That related to the extension of Megan Wolf as administrator of WEC. Certainly something a lot of conservatives didn't want to see. But if you look closely at the case, the decision is based on the Prane decision, Doc Prane, who sat on the DNR board. So at least the court was willing to, even though it was kind of begrudgingly, they showed
be consistent.
They tried to be consistent.
Mm-hmm.
Now there's some interesting concurrences there. Justice Ann Walsh Bradley had a concurrence along with Rebecca Bradley, and there's some back and forth where basically Rebecca Bradley is asking, are they actually trying to be consistent, or is this just the outcome they want? And I guess your listeners can read that opinion and decide for themselves. But at the end of the day, it was a 9-0 decision. And then finally you have SEIU versus Work. This is a case relating to collective bargaining for UW hospital employees. And the court, in another kind of 9-0 decision, so unanimous, but with some concurrences and some bickering among the concurrences, it's still 9-0. And basically the court said no, under kind of the Post-Employment Peace Act, Post-Act 10, these employees can't collectively bargain. So I'm just pointing those out as 3 decisions where the court got it right. Might have been some concurrences, but that's pretty typical, right? You're going to see some debate when you have concurring decisions. On the other hand, there certainly are a series of decisions that the court just got, in our view, fundamentally wrong. And I'll break it down by category, and then I'll pause, Meg, in case you have any comments or questions. But what we try to do is you can just kind of go through the line of cases, and it gets confusing. I mean, even as myself and Daniel Sir and Kevin, our fellow, we're the authors of the report, and even as the authors, it would sometimes get confusing about kind of how the cases relate. And so there's actually Alicia from our office had a great idea. Let's do categories and break it down by substantive areas, and that's going to give some focus to the report. And so what we did was we looked at first bureaucracy. If you look at separation of powers, that category of cases is critical. That's probably the area where, in our view, the court got it most wrong. You look at, obviously, abortion. We talked at length about the abortion decision. And then third was gubernatorial veto authority. That would be the third category. And there, you kind of have conflicting opinions. But we also add a category relating to election integrity, religious liberty, and then collective bargaining, Act 10. So that's kind of how we organize the cases. And when you do it that way, you start to see kind of a theme from this current court and can draw some lessons learned and what comes next. And that's ultimately what I think the value of the report is okay, we could just go through and summarize every case in detail. I'm not sure what the value of that is if you're not a lawyer. So what we try to do is we certainly try to provide some analysis as to kind of what the court decided. But more importantly, then we break these cases down into categories, and then we kind of highlight, what comes next and how does this really impact state operations.
So, Jake, we're at a breaking point. 10:30 News is up next. I don't know, do we want to resume our conversation next week or continue after the break? Up to you.
I say let's keep rolling, Meg.
All right, okay. So hold tight. Jake Curtis from Institute for Reforming Government graciously is holding over during the break. We shall return after this news on WSAU. Rejoining me after that news break from Institute for Reforming Government, Jake Curtis. So, Jake, before we resume our conversation, just as a reminder to our listeners, can you talk a little bit about your organization, your organization's mission, and why you exist?
Sure, absolutely, Meg. And I guess thanks for that opportunity. So, Institute for Reforming Government is an organization that really, we like to say we focus on kitchen table issues, which, is obviously a very generic way to describe what we do, but we think it's important because we focus on the issues that we think people care about. We do a lot of polling, and which I think really drives what we do, not in the sense that, we're driven by the polling results necessarily, but we do want to know what people think and what are the issues that are important to them, and focus on putting out work product and encouraging legislators and the grassroots to consider various solutions. So when you look at something like the income tax in Wisconsin, we're the leading organization that has been advocating for elimination of the income tax. Chris Reeder from IRG has done some great work in that space. And look, if we want to be, I think you and I have talked about it before, Meg, if Wisconsin wants to be competitive, it needs to think boldly. I mean, that's the problem, I think, with the current administration. It's just kind of more of the status quo, growing government, not thinking about competitive policy solutions. Problem is, we're a union of 50 states, and I know people that just want to constantly grow government don't like this, but I think it's good to have a system whereby we don't have centralized government. We talked about this last week, this principle of federalism, that certain powers will reside with the federal government, and the remaining powers are reserved to the states. It's critical to our government and to how we frankly exist as a country. And because of that, though, we have a very competitive climate among the 50 states. And so when you look at something like the income tax, the reality is states like Florida and Texas and Tennessee and I believe the state of Washington, right? So not even a conservative state, New Hampshire. There are states that don't have an income tax, and on that basis, maybe not the basis alone, but when you throw in other factors, are simply going to be more competitive than Wisconsin. So again, so why would our IRG focus on that? Because we want Wisconsin to be the most competitive state in the union, where people stay to grow business, grow a family, retire, vacation, whatever the case may be. And if we're not competitive, then we're just simply missing out on opportunities to grow. And when you look at education, we do a ton of work in the education space because the reality is, if we don't have public schools that can operate at a sufficient level, such that you actually have kids that are graduating that can read and write, right, pretty basic stuff, and as Quinton has shown, and frankly others have shown, when you look at MPS, the largest public school district in the state, it's just not, we're not making the cut because these kids we're failing them. They can't read and write at sufficient levels, and these kids then graduate and go off into the workforce. And so we do a lot of work in that space. We certainly support kind of an above the board approach to education, school choice, charter, homeschool options. I've talked about that before. So we want parents to be empowered and make the choice that's right for their family. But we also know that if you have something like MPS or Madison or Green Bay, right, the large school districts in the state, if they're failing, that's failing the entire state. And so we do a lot of work in that space. And then obviously, in addition to the court watch, I do a lot of work in the administrative law area. We've talked about this before, and I certainly have appreciated you having me on over the last year or so to talk about administrative law. It sounds like kind of this wonky issue, but at the end of the day, regulations have costs. Wisconsin is the 13th most regulated state in the country, about 165,000 regulations on the books. That all has a cost. And I would encourage your listeners, right, if they start to tune out because we're talking administrative law, I would just ask them, think through your normal daily interactions, right? Let's say you're involved in the construction industry. How many permits do you need to pull if you're working for a company and you're putting up a new home? How many environmental regulations do you need to work through, whether it's the DNR or your local county? Look at any area of life. There's regulation. Now, not all regulation is bad, right? Some things need to be regulated, and there's kind of consensus. But what I always say is we have to recognize the cost. That's the biggest mistake when it comes to regulations and administrative law, administrative procedures, is you cannot ignore the cost. And policymaking is always going to be cost-benefit analysis. As long as you're recognizing the cost, if you think the public good outweighs that cost, then that's a reason to implement that regulation. But if it doesn't, right, if the costs outweigh any sort of public good, then one has to question whether or not that regulation is necessary or appropriate. And I think far too often, policymakers, either certainly at the federal level, state level, even local levels, I don't think they go through that analysis. So a lot of the work we do on the administrative law front is to try to show what are the costs of regulations, how does it impact the regulated community, which a lot of times people think big businesses. Well, sure, it's big businesses. It's also small businesses. It's nonprofits. It's other units of government. I mean, that's a storyline that we've talked about that nobody ever talks about. I mean, there's so many regulations put up by the state that impact local units of government that are then passed on to those residents. And so those are the things we talk about on the administrative law front. So again, kitchen table issues, that's what we focus on at IRG. We want to be relevant. We want to offer real solutions and hopefully bipartisan solutions. And but even if they're not, hopefully we change minds and make it clear why limited, smaller government, respecting property rights, respecting individual liberty, those are all kind of the foundational principles that the conservative movement is built on and has delivered really significant results in Wisconsin. When you look at like the Walker administration, huge reforms. I mean, in the administrative law space, the reforms advanced during the Walker era were really a national model, and because it's not the government that makes Wisconsin great, it's the people. And so we're conservative, right? We're not libertarian. That there are going to be certain areas where there should be regulations. We want government. We want orderly, way to do business in Wisconsin. But it should be as little government as possible, right? Because ingenuity and energy, it comes from the individuals in the state, not government.
Well, and so, I mean, ultimately, you want to influence our legislators. And so a piece of that, I would imagine, or a chunk of that, of your efforts, go towards developing and cultivating relationships with our elected officials.
Yeah, so we have a C3, a 501c3. That's Institute for Reform in Government, and that's where we put out kind of our key policy work, our work product. We also do have a C4. So for those that are familiar with kind of the nonprofit world, C3 is nonpartisan, and you're just kind of putting out objective work product. And a C4 you can actually use to use like an action component, right? You can actually advocate for or against policy proposals, and we do have a C4. So yes, we want to put out relevant reports and relevant analysis that legislators can use to then make good policy decisions. But again, maybe to get back to the report, we also think what we're doing that's unique is focusing on Wisconsin state courts, starting with the Supreme Court, hopefully moving on here going forward to the courts of appeal. We think that's really critical because, right, there's always so much focus on the executive branch and the legislature, and we often forget, both at the federal level and at the state level, that there's a third co-equal branch of government. And as we're seeing right now, that co-equal branch can have a significant impact on state operations. And so, we had started out earlier talking about where, okay, the court showed some restraint. There unfortunately were areas where they haven't. And so, remember, we had kind of broken down our report by category. When you look at bureaucracy, we think that the Evers versus Markline case is a case that everybody needs to pay attention to. It is extremely problematic in that it's removing the ability of the Joint Committee for the Review of Administrative Rules. I know it's a mouthful. JCRER is what we call it. That's basically the committee that's set up to review administrative rules. One of the Walker era reforms was JCRER had the ability to pause, object to, or suspend administrative rules. That was struck down by this court as unconstitutional. And that's a problem because that was an important tool that JCRER had to review an administrative rule, like I mentioned earlier, that might have a cost. The legislature would want to pause a rule and review and consider whether or not the cost was worth any sort of public benefit. And so now based on this decision, Evers versus Markline, that was a 5-2 decision. The court ruled that unconstitutional. JCRER doesn't have that authority. A second problematic decision was WMC versus Natural Resources Board. This essentially related to the use of the spills law to identify PFAS as a contaminant, as a hazardous substance. The problem is that should have gone through the rulemaking process. And essentially, the outcome of that case is we think bureaucrats are going to be empowered to use guidance documents instead of the traditional rulemaking process. Guidance documents, right, they're essentially these documents that are viewed as guidance that agencies put out. They typically don't go through the rulemaking process. They should, and if they don't, they essentially, in the view of these agencies, many times will have the force of law. And this decision, I think, will empower bureaucrats to use additional guidance documents. And right from a fundamental standpoint, that's problematic because the regulated community, they're not going to have the same notice and the ability to comment on a guidance document. It's essentially just issued by the agency. So I think when you look at that category, that's an example where this court has had a significant impact. This is going to impact state operations. It's weakening the ability of the legislature to review administrative rules. It's strengthening the executive branch and the bureaucrats that are in the executive branch to essentially rule by guidance. And if your listeners aren't tracking, think at the federal level all the turmoil that came about via these very radical interpretations of Title IX by the Department of Education. Those are essentially guidance documents, right? So when you think of it in those terms, we know why this is problematic. The people's representatives in the legislature have to have an ability to review e-rules. Our polling shows it's a bipartisan issue. Individuals want the legislature to have a say. And so by removing these tools from the legislature, this court has significantly weakened oversight from the legislature. So this is a category where they did not show restraint. They may want to frame, those that supported a progressive court may want to frame these as really technical decisions. I mean, yes, they're technical, but they're going to have significant impact on state operations. And I'll address one more category. When you look at like abortion, we talked at length about this. Obviously, has a significant impact on a key cultural issue, but from a legal standpoint, this is probably the best example. The court, it was very clear. You listen to those and watch the oral arguments. It was very clear where this court wanted to go when it came to the issue of abortion. And when by relying on a very kind of technical doctrine, implied repeal, that basically later passed statutes after the 1849 law essentially meant that the legislature was impliedly repealing the 1849 abortion prohibition, simply is just kind of a technical way for the court to strike down the 1849 law and really implement their preferred values. And so really just an exercise in raw judicial power. So a very problematic decision. So again, I don't want to kind of make it seem as though that this court was not progressive. They were extremely progressive, the most progressive since 2008. And while they showed some restraint in kind of limited circumstances, if you look at some of these categories, they definitely were willing to push the court in a leftward, more progressive direction.
Well, Jake, what I think is be careful what you wish for, because I just think eventually the pendulum is going to swing back, and there's a distinct possibility that we will have all three branches of government again, and then what will Democrats do with what they have foisted upon Republicans?
Well, that's a great point, Meg, and actually that's kind of a nice little segue into another category we haven't talked about, but we did have a category relating to gubernatorial veto authority. I had mentioned a positive case, legislature versus DPI, which was 9-0. It was a Bradley decision relating to the governor not being able to use partial veto for a non-appropriation bill. However, this is a category where we kind of had conflicting decisions, a good decision and a negative decision. If you look at Lemieux versus Evers, that was the 4-3 decision issued that is increasing revenue limits for the next 402 years. This case got a lot of coverage. I'm sure we talked about it, Meg. But basically, by using the veto pen, and the Wisconsin governor already has one of the strongest veto pens in the country, by using that veto pen to kind of cobble together words, take out letters and numbers, and create new words and numbers. By doing that, Governor Evers was able to extend an education revenue limit from 2 years to 402 fiscal years. Yes, 402, 4 centuries. And so when you look at it from kind of a separation of powers perspective, there's no conceivable way that this legislature had any intent to increase education revenue limits for 400 years. And yet the governor, by using his veto pen, essentially made it a legislative act, right? And that is right, everybody kind of back to Government 101. The legislature proposes legislation. It's a bill that goes to the governor, if it's passed both houses of the legislature, for him or her to sign, right? This is basic Government 101. The governor does not have the ability, or should not have the ability, to essentially create a new bill by way of his veto pen and then sign it. And that's actually an example of Justice Hagedorn. Again, a lot of people have been critical of him. He had some good decisions and good dissents. He was wrong, in my view, on a few others. I think he actually got the bureaucracy category cases wrong. But on the gubernatorial veto decision, he got it right, and voted with the conservatives, knowing that it was going to be problematic to have this sort of authority rest with the governor. And that's an example of where, as you said, Meg, if the pendulum swings, that next governor, after this decision, it's probably fair to say the most powerful veto pen in the country. And whether the court was thinking about that, I think they do think politically. I don't know, but I think the point you're making is absolutely a fair one. That this could swing back, and the Wisconsin governor now will have an extremely powerful veto pen.
Is it a veto auto pen? Just kidding. We have to get going, but I want to ask you final question of the morning. What must we brace for next? I mean, what do you expect the next decision by the Supreme Court is going to be?
Yeah. I think no secret here. You and I have talked about this at length, and we actually include a section on Collective Bargaining Act 10 in the report. So on the one hand, this is, again, a situation where the court actually got it right. SEIU, healthcare versus work. That was a 9-0 decision. We talked about that earlier, where UW hospital employees don't have the right to collectively bargain. Unfortunately, a decision is working its way up through the Court of Appeals. There was a decision out of Dane County that struck down Act 10 as unconstitutional. You and I talked about that at length a few months ago. That case is now on appeal in front of the District 2 Court of Appeals, a conservative district that should get it right and overturn the Judge Frost decision, finding that there was no rational basis for Governor Walker and the legislature's decision to implement Act 10. That decision from District 2, and again, I'm making a prediction, but I'm pretty confident District 2 will get this right. That then would go up to the court, the Supreme Court. That's. I don't see how that's not the most significant decision in this next term. From a legal standpoint, if we weaken rational basis, that because we've been trying to be objective, right? For example, implied repeal, I don't think that's going to be some huge avenue for the court to undermine all the Walker-era reforms. Weakening rational basis review would absolutely allow the court. That would essentially be kind of that Pandora's box. And then from a policy standpoint, striking down Act 10 will have a significant impact on local units of government. They're going to have to collective bargain with every unit in
taxpayers
in the county, in the town, in the village, whatever. And then, it was kind of cliche, but I always believed Governor Walker hit the nail on the head when he said, "What's Act 10 about? It's about taxpayers having a seat at the table."
Amen. I got to let you go, Jake. We're out of time. Hey, great to chat with you. Look forward to our conversation next week. Thanks so much for taking a full hour today to chat. I appreciate it. Hope you have a wonderful day.
Thanks, Meg.
Thanks.
Talk next week.
Yep. Talk soon. All right. Hey, on that note, got a boogie. Have a great day. God bless. Talk with you again tomorrow.